From 1989 to 1995, Nurse Kristen Gilbert murdered 4 of her patients at the Veterans Affairs Medical Center in Massachusetts, and she's suspected of killing dozens more. On Mind of a Monster, a podcast from ID, criminal psychologist Dr. Michelle Ward dives into Kristen Gilbert's twisted mind to try and find out why she killed her patients and how she was able to do it in front of her colleagues. She speaks with detectives, journalists, nurses, and victims' families to unpack Gilbert's life and crimes on Ward C. Listen to Mind of a Monster, The Killer Nurse, wherever you get your podcasts.
What makes a great pair of glasses? At Warby Parker, it's all the invisible extras without the extra cost. Their designer quality frames start at $95, including prescription lenses, plus scratch-resistant, smudge-resistant, and anti-reflective coatings, and UV protection, and free adjustments for life. To find your next pair of glasses, sunglasses, or contact lenses, or to find the Warby Parker store nearest you, head over to warbyparker.com. That's warbyparker.com.
Hi, I'm Jessie Prey.
And I'm Andy Cassette. Welcome to Love Murder, where we unravel the darkest tales of romance turned deadly.
Our episodes are long-form, narrative-driven, and deeply researched. Perfect for the true crime aficionados seeking stories beyond the headlines.
Like the chilling case of Blanche Taylor Moore, the so-called Black Widow who left a trail of poisoned lovers.
Or the shocking murders of Chad Shelton and Dwayne Johnson, where family ties masked a sinister plot.
Subscribe to Love Murder on Apple Podcasts, Spotify, or wherever you listen.
I'm Alice.
And I'm Brett.
And this is The Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always by my imaginative co-host, Brett.
Oh, Alice, it's good to be here with you. I always enjoy discussing Supreme Court decisions with you. It's always fun.
Did you like how you thought I was going to say something, but I didn't say it? I said imaginary, but really we're talking about immigration today.
Immigration.
Not anything hot or anything. It's a pretty boring legal episode, actually. No controversy coming from it. The most controversial thing I've said today is that I loved Taylor's new album, Life of a Showgirl. So from here on out, easy sailing.
Easy sailing. And yeah, so we're going to talk about immigration today. And I would just note for everyone out there, you guys always ask us to discuss these cases. And then people get upset with what we say. So just a reminder, this is not about politics. It is not about your position on immigration or not immigration. This is about the Supreme Court, recent decisions the Supreme Court has made, explaining those to you so that you know them as you move forward. Whatever your position is substantively on the policy, this will help you make your arguments to your friends or your enemies or whatever, so you have a good handle on what's going on in the legal system these days.
Indeed. So, of course, the case we're talking about is Noem versus Perdomo. Now,
Perdomo,
this case...
great cigars, by the way. That's what I kept thinking the whole time I was reading this opinion. I was like, great cigars.
We told you, this is not political. Although, PSA... don't smoke, kids. That's not
true.
Good for your lungs.
Smoking
there you go.
is bad. Yeah.
Smoking is bad. But somehow when you're 18 and older, it's not bad.
You don't inhale cigars, though. So it's more bad for your mouth.
It sticks to you. Like, I still feel it in my lungs when I'm at a cigar bar. It's been a long time since I've been at a cigar bar. Nevertheless, back to the issue at hand. The case that went up to the Supreme Court is Noem versus Perdomo. And of course, this case dealt with illegal immigration enforcement in Los Angeles. So
I want to say one thing about this before you dive into the case itself. I just want to say one thing. And this is, you guys, if you've been listening to Legal Briefs, you know we did an episode on the emergency docket, the shadow docket, some people might call it. You should go back and listen to that, because that is the the posture of this case. This is a case that came up on the emergency docket. So if you look at the opinion, it's really interesting. There's no majority opinion. There's just a concurrence, which sort of explains the majority's thinking, and then a dissent, because these are just sort of these, I mean, it's hard to describe it. Go back and listen to the episode, but just to give you that. So if you go look for this opinion, you'll only find the concurrence because there actually isn't an opinion of the majority.
Very fair. Yes, go read the opinion. Absolutely. So of the 20 million people or residents who live in LA, approximately 2 million of them are there undocumented. Immigration officials in Los Angeles began enforcement operations that involved brief detentions and immigration status checks. Now, these checks were set at locations where people are hired for day jobs because that's where a lot of undocumented immigrants go seek work. And it targets those who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often don't require documentation for your legal status here in order to work. And that's why those particular jobs seem to be attractive to illegal immigrants and those who don't speak much, if any, English. Now, a district court judge in California enjoined these enforcement actions, holding that immigration officials could not make stops based on the following factors. 1, the presence at a particular location, such as bus stops, car washes, day labor pickup sites, agricultural sites, and the like. And second, the type of work that one does. Third, speaking Spanish or speaking English with an accent. And fourth, apparent race or ethnicity. So this injunction was appealed to the Supreme Court on an emergency basis, as Brett just mentioned, and the court lifted the injunction, meaning the court's decision could not enjoin the government's enforcement actions. That decision by the Supreme Court was 6-3, 6 in favor, 3 opposed to lifting the injunction. But the court does not tend to issue full opinions in these types of emergency cases, and they did not do so in this case. But Justice Kavanaugh wrote a concurrence explaining the decision, and Justice Sotomayor wrote a dissent for 3 dissenters. What that means is there's no majority opinion. Even though Kavanaugh's writing explaining the decision, it's just a concurrence. It's not the majority joined by all 6 who voted in favor of lifting the injunction.
And so these injunction opinions are always really interesting to law nerds such as us, because it's not about the merits. So the Supreme Court is not necessarily saying, hey, this is fine. You can totally do this, no problem. That's no binding precedent for the country, right? But it is somewhat about the merits, because when you tackle one of these injunctions, one of the things the Supreme Court is supposed to consider is likelihood of success. So, hey, government's been enjoined. Should we lift that injunction and let them move forward? Well, if they're going to lose eventually, like if we feel strongly they're going to lose, then we're not going to lift the injunction. They're just going to be enjoined, then they're going to lose. And that way, whatever damage they might have done doing this illegal thing in that period doesn't happen because you had the injunction in place. Another thing we're not going to talk a lot about, but also comes up, is sort of the balance of harms with these injunctions. So the government's saying, hey, we're being harmed whenever we're enjoined because we have this policy, we're trying to enforce the law. We have a court saying, no, you can't do that. And then you have the harms of the plaintiffs. And the plaintiffs are saying, look, our constitutional rights are being violated. We're being stopped without any legitimate purpose. We're being racially profiled. That's what they're saying. And so you also have to balance those. Now, to be honest with you, even though that's a factor, it almost never matters. The likelihood of success is the big one, and that's the one where you sort of see a lot of these decided. And in the concurrence that Kavanaugh writes, even though it's not about the merits, he spends a lot of time on the merits of this lawsuit. So first, he addresses the boring stuff, standing. And so in so many of these cases, you'll see an issue that people are really passionate about and want an answer to. But at some point, the courts are like, I get that you're passionate, and you might even be right, but you don't have the standing to bring a challenge. We're just going to have to do an episode on standing. I always say it's boring. Maybe you guys would love it. I really hate standing. but nevertheless,
I hate standing, but it's literally like the foundation of the house. Without it, there is no case. There's no house.
It's true. It's true. And that's essentially what Kavanaugh says here. He's like, look, there's a 1983 Supreme Court case almost directly on point. Los Angeles versus lions. And he describes this pretty succinctly. So I'm just going to read you what he says. And basically he's saying, look, the plaintiffs don't have standing. Like, even if they're right, they don't have standing to bring this lawsuit. And so if you don't have standing, how are you going to win? How are you going to have likelihood of success? Here's what he says. Plaintiff's standing theory largely tracks the theory rejected in Lyons. Like in Lyons, plaintiffs here allege that they were subjects of unlawful law enforcement actions in the past, namely being stopped for immigration questioning, allegedly without reasonable suspicion of unlawful presence. And like in Lyons, plaintiffs seek a forward-looking injunction to enjoin law enforcement from stopping them without reasonable suspicion in the future. But like in Lyons, plaintiffs have no good basis to believe that law enforcement will unlawfully stop them in the future based on the prohibited factors, and certainly no good basis for believing that any stop of the plaintiffs is imminent. Therefore, they lack Article 3 standing. And essentially, just to give you a very quick rundown on this, if somebody does something to you and it's illegal and they violate your rights, you may be able to sue them and you may be able to get damages, right? But if what you want to do is change some future policy, you're not going to have standing to do that because you have to show an imminent harm. So it has to be something where you can show that if you don't stop them, you're going to be harmed. So imagine like the city wants to take your house. And they already took your farm, right? They took your farm, but they left you with the house, but now they're going to take your house, right? You could sue them for taking your farm and saying, look, you did that illegally. I want damages for my farm. I want the fair market value. But you couldn't sue to stop them from taking your house unless it appears that they are moving forward to do that as well. So if you have some indication they're also going to try and take my house, then you could sue and say, hey, court, prohibit this government from taking my house. Here's all the evidence they're about to do it, right? And then you would have standing for the house part as well. So in this case, Kavanaugh's saying we have this long-standing thing that just says you can't sue to enjoin a practice just because it happened to you in the past. There has to be some indication it's going to happen to you in the future. So that's sort of the standing argument. And he could have just stopped there. You can't get an injunction without standing. So the plaintiffs were doomed to failure, no matter what the value of their substantive arguments. But I think he understands that this is going to be a controversial decision. So he decides he's going to go ahead and address the chance of the plaintiff's success on the merits, which is also, as we said, a key question when staying an injunction.
So immigration officers in Los Angeles were operating pursuant to a statute. That's 8 U.S.C. Section 1357A1. And it reads, any officer or employee of the service shall have power without warrant to interrogate any alien or person believed to be an alien as to his right to be or to remain in the United States. Seems pretty straightforward.
And very broad. I mean, that's
very,
really
very broad, right? It doesn't just have to be someone who is undocumented. If you have a suspicion that they're undocumented, you get to be interrogated, is what that statute says. Now, the Supreme Court has interpreted this statute to allow brief detentions of persons if officers, quote, have a reasonable suspicion based on specific articulable facts that the person being questioned is an alien illegally in the United States. Now, in any other criminal context, this is known as a Terry stop. Reasonable suspicion is one of the lowest burdens of proof in the law. It's less than more likely than not, and it's even less than probable cause. Typically, if it's more than a hunch and the officer can point to a specific reason for the stop, it's going to be lawful. Now, you'll see this in traffic stops, for Terry stops specifically, in instances where they could just be like, when I asked him a question, he nervously looked down at his console. He repeatedly looked down at his console. And in my experience, when someone does that, it's because they have an illegal weapon there. And so I took next steps. Like that could be an articulable suspicion. As you can see, it doesn't have to be a very high burden there. And this is to allow law enforcement to do their jobs.
And in Terry itself, so basically there's a cop, I think it was in Chicago, and he's like, sitting in his car and he sees a guy walking down the street and the guy stops and he looks in a jewelry store. And so he sort of looks at some stuff for a while and then he walks down the street and he talks to some friends of his that are kind of hanging out at the end of the street. And then he turns around and he walks back and he looks in a jewelry store again. And so this officer thought, these guys are casing this place. They're going to rob it. So he walks up to them, one of whom is named Terry, and basically grabs him, spins him, and finds he has a gun. And he's arrested, and this goes all the way to Supreme Court. And Supreme Court basically says, like, hey, if you're a police officer and you can point to a reason why you're stopping somebody, you can do these very brief stops. They're supposed to be short, not long at all, not super intrusive, but you can stop somebody and talk to them. And like Al said, you see this in traffic stops all the time, right? I mean, there's all sorts of different circumstances where this happens, and that's this reasonable suspicion standard comes from Terry. Guys, if you're like me, your house might be quite a mess. And, we blame the kids, we blame the dogs, we blame the secret ghost hiding somewhere in the house. But the fact of the matter is, we just don't have a lot of time to clean. And that's where the Green Mitt Kit comes in from Clean Safe Products. It is the easiest way to keep your fabrics looking brand new in 5 minutes or less. The process is simple. Spray the solution, wipe, rinse, and repeat. If you can clean a kitchen counter, you can clean your couch. It works on carpets, couches, car seats, wool rugs, delicate upholstery, even dry clean only materials. You can avoid the nightmare of bleach spots or harsh chemicals in your living room. The Green Mint Kit is non-toxic, fragrance-free, and made with just 3 ingredients. And because it's soap-free, there's no sticky residue, no stains, magically reappearing the next day. I love Clean Safe Products. I love the Green Mint Kit because it lets me keep my house clean without spending a ton of time doing it. You guys know we don't have all day to do things like clean the house, and frankly, that's one of the things that kind of slips sometimes. Well, with the Green Mint Kit, you can keep your house clean and do it in a way that saves time for you. So try it risk-free. Clean Safe Products offers a 30-day money-back guarantee, no questions asked. Go to cleansafeproducts.com/prosecutors now to get $15 off the Green Mint Kit. That's cleansafeproducts.com/prosecutors for $15 off the world's easiest soft surface cleaning solution. This episode is brought to you by Progressive Insurance. You choose to hit play on this podcast today, and that was a smart choice. Progressive loves to help people make smart choices. That's why they offer a tool called Auto Quote Explorer that allows you to compare your Progressive car insurance quote with the rates from other companies. So you save time on the research and can enjoy savings when you choose the best rate for you. Give it a try after this episode at Progressive.com. Progressive Casualty Insurance Company and affiliates, not available in all states or situations. Prices vary based on how you buy.
Shopify is a platform built for growth, whether you're just starting out or already running a thriving business. From managing inventory to creating a seamless checkout experience, Shopify is designed to handle it all. And it doesn't stop there. Shopify helps you sell everywhere your customers are, online or in person. It's the ultimate tool for turning big dreams into big wins. Sign up for your $1 per month trial period at shopify.com/OPP.
Now, Kavanaugh wrote that under the court's precedent, not to mention common sense. Now, the factors used by immigration officials could, when taken together, constitute reasonable suspicion. Now, Kavanaugh explained that to find otherwise, the court would need to overrule at least 2 separate lines of precedent addressing similar immigration-related questions. Kavanaugh was careful, though, to note that ethnicity alone was not sufficient to justify reasonable suspicion. So you can't just stop someone because they look like they're from Latin America, for example.
And that's why it was important that there were all these other factors, right? Remember, the district court basically said, hey, you can't stop somebody because of where they are, because of where they're working, or all these various other things. And so Kavanaugh's saying that's different from just stopping somebody on the street because they appear to you to be Hispanic, for instance. And that's the distinction he's making, and why under the sort of reasonable suspicion idea, this is something that you would be allowed to do. Now, Justice Sotomayor wrote for the dissent. And I feel like it's interesting, the dissenters. This is a 6-3 court. I personally think it's a 3-3-3 court. I think there's 3 conservatives, 3 liberals, and 3 justices who are lean right, but are more in the middle. And Justice Sotomayor, it seems to me, is often chosen to write for the dissent. She's really good at capturing sort of the general feeling in the public about whatever she's talking about. So she's good at doing that, and also then talking about sort of the legal basis for what she's going to do. And you see her do that in this dissent. And she begins by asserting that, quote, "We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job." Now that's, once again, a very sort of, she's tapping into this sort of ethos or the zeitgeist of some of the opposition to immigration enforcement. And doing that, as she describes these enforcement actions, she's also tapping into that as well. She describes the actions, masked agents with rifles sort of showing up in vans and jumping out and raiding warehouses, agricultural facilities, and locations where day laborers were known to gather. She talks about how these are spreading panic and fear throughout Los Angeles, and she notes that, quote, "Some have likened the detentions to kidnappings." Now, none of this really bears on the reasonable suspicion question, but it's very powerful rhetoric. And as we've said before, the thing about these judicial opinions, particularly at the Supreme Court, I mean, they are speaking to the public. I mean, they're not supposed to be overtly political, obviously. They're supposed to talk about the law and not sort of substantively political ideas about how we should do immigration enforcement, right? But nevertheless, I mean, she is speaking to a public audience, and she's very good at it. And you see that if you read her opinion. And this is really powerfully rhetorically. So if you're ever, all you guys out there who are trying to write something to influence people, I mean, one way to do it is you sort of capture people at the beginning with your rhetoric, right? Then you lay out your reasoning, in this case, your legal reasoning. And if you have already captured them with your rhetoric, they are more likely to believe your reasoning, even if your reasoning isn't the strongest part of your argument. It's very effective, and I think that's what she's doing in this opinion. And she focuses on Latino U.S. citizens who have been detained, which obviously they're the plaintiffs. I mean, the plaintiffs are U.S. citizens, but it also, I think, is another rhetorical point that she's making here. She's not talking about people who actually are here illegally, right? That's a weaker, even though the same legal analysis applies, because it doesn't matter if the stop is unconstitutional. It doesn't matter if the person is actually engaged in criminal conduct, right? Like, you don't get to say, well, hey, we found 10 kilos in the car, so therefore the search of the car was legitimate. You don't get to argue it like that. But it is more powerful to focus on people who were stopped and then turned out to be U.S. citizens. And she talks about those folks. She talks about how one was detained for 20 minutes, which I don't know if that's brief or not. In my experience, I feel like that's not that long, but I think most people who've never been detained by the police probably think that is a long time. So she talks about that. She talks about someone who had to leave where they were working so they could prove that they were here legally. And she talks about these kind of folks. And all this is happening while officials are determining their legal status. And she goes on to say, the government has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction. So then she turns to the legal allegations. So she's sort of, as I said, she's made this really sort of powerful rhetorical argument about this, but then she's going to talk about the law. And she explains that the lawsuit was based on the idea that broad profiles and apparent race and ethnicity could not alone constitute reasonable suspicion. What's interesting about this is everyone agrees about this, right? So Kavanaugh, in his concurrence, says the same thing. But what she does, she's able to take that and twist it just a little bit to say the distinctions that you made, Kavanaugh, and that the government made don't really make a difference, because the lawsuit goes further. It also said that even if you take all the factors that we talked about above and that she's discussed, even if all of them were present, that would not constitute reasonable suspicion. Rather, officers need something specific to the person themselves to be detained. Now, this is actually a pretty interesting legal question. and it has implications for all of criminal law and reasonable suspicion stops. As we talked about, this is a pretty well-developed area of the law, and oftentimes the reasons for stopping people are not actually specific to that person. And this is something in other contexts that has been criticized. I'll give you an example. High crime areas. So if you are walking through a high crime area, that can be a reason for the police to stop you. Now, that doesn't say anything about you, right? That's just where you are. Like, you happen to be walking through a high crime area. And a lot of people have pointed out that what the police define as a high crime area often tend to be lower income areas of the cities, which also often happen to have certain racial characteristics. So it'll either be heavily African American or heavily immigrant. And those are the places that police have staked this ability to stop people just based on the fact that they're there. You know, and usually it's like a high crime neighborhood late at night. So like somebody's walking through a high crime neighborhood, it's 2:00 in the morning, and they're wearing a coat and it's not that cold outside, right? Like, that would definitely be enough. They could absolutely stop you. So she's sort of like tapping into that as well to talk about this. And I feel like it's pretty effective because this particular approach is really not individually specific at all. It really is about a bunch of different characteristics where if you put them together, it makes it more likely than the person that you're targeting is committing some sort of crime.
So as Brett said, this is really interesting because this goes, what Sotomayor is talking about goes beyond just the immigration context. So we'll come back to this, but in any event, the district court injunction stated, quote, defendants may not rely solely on the factors below alone or in combination to form reasonable suspicion for a detentive stop, except permitted by law. And then it goes on to say these are not permitted: apparent race or ethnicity, speaking Spanish or speaking English with an accent, presence at a particular location, such as the bus stop, the car wash, the tow yard, day labor or pickup sites, agricultural sites, etc., or the type of work that one does. Now, this was proper in Sotomayor's view because the court's precedent is clear that facts that describe a very large category of presumably innocent people cannot constitute reasonable suspicions. Here, Sotomayor is pressing on the need for individualized suspicion specific to that person to be able to detain them or interrogate them. And she cites cases for the proposition that general suspicion is not enough. Being near the border, for example, being in a dark alley in a high crime area, for instance. Sotomayor then cites to the controlling case in this area. The same one, interestingly, that Kavanaugh cited to, the 1975 decision in Brignone Ponce. In that case, Border Patrol asserted that they could detain anyone in a private vehicle near the border with Mexico because most illegal immigrants leave the border area in private vehicles. Now, the court noted that allowing this would, quote, subject the residents of those and other areas to potentially unlimited interference with their use of the highways solely at the discretion of Border Patrol officers. Now, the court said that other factors were necessary, such as the way the driver's acting, whether the vehicle was, say, overloaded with passengers, and whether anyone tried to hide when the Border Patrol officer looked in the car.
And one reason I love this stuff, I love Supreme Court precedent, is because I was a philosophy major in college, and philosophy, politics, the law, at some point, you just either agree with it or not. Like, you feel it. Right? Like, it either convinces you or it doesn't. It's not like a scientific thing. It's not like, well, they've added an extra pebble to the scale, so therefore the scale is now in their favor, they win, right? And you listen to this, and don't you just feel that obviously you can't do that? Like, you obviously can't just stop every private vehicle near the border because they might have an illegal immigrant in them. And we have evidence that illegal immigrants tend to travel in private vehicles. Like, you just feel that, right? Like, is there anybody out there listening to that who thinks, no, that's crazy. Obviously, they should be able to do that. I don't think there will be. I think most people are like, yeah, that feels like too much. And so what ends up happening here, Kavanaugh's citing this case, she's citing this case, because they're both trying to say this current circumstance is, in Kavanaugh's opinion, very different from that. And in her opinion, very close to that. And so as you're thinking through it, you have to decide, is this notion of you see somebody who's at a day laborer pickup spot for like an agricultural thing where everyone knows there tend to be a large number of people who are not here legally who work those jobs, who has an ethnicity, appears to be Hispanic, who doesn't speak English. Like if you add all those things together, does it give you reasonable suspicion to stop that person? Or does it feel more like this whole stopping the private car near the border thing? Like which one is it for you when you hear that? And it is interesting here because she has a point. I'll say this. When I read Kavanaugh's thing, I thought, well, this is obviously right. I mean, the standing thing's pretty hard to get around, but like, it's like, okay, I see. You know, you got reasonable suspicion. You're putting all these different things together. You're not just saying it's based on race. You're doing on more than that. But Sotomayor's like, hey, you kind of are saying it's based on race, right? Like she points out, like race isn't just what you look like, you know, like the fact that you don't speak English is something that might be attached to race. Just because you don't speak English doesn't mean you're not here legally, right? Or like the fact that you work certain jobs. Like she's pointing out a lot of these things kind of sound like you're really just saying, hey, you're a poor brown person, therefore we get to stop you, right? And that's essentially what she says. And the point that she makes about the lack of individualized suspicion, that there's nothing in any of these factors about that person. Think back to the Brignoni-Ponce case, right? So the court's saying, look, it has to be factors other than ethnicity, other than just being near the border. It has to be something else. But what do they point to? They point to specific things about the person being stopped. The driver's behavior. That's a specific thing. Was the vehicle overloaded with passengers? It's a specific thing. Like, is this particular car you want to stop? Is it filled with people? Right? Whether anyone's trying to hide. Is someone evincing suspicious behavior? Right? And I think she has a really good point here. Now, I think where she gets shaky, she does talk about standing, and she suggests that because the plaintiffs were likely to return to the places that were previously searched, and because the government also might return to those locations at some point in the future to sort of do these roundups, that was enough for likelihood of reoccurrence. I find this to be a pretty weak argument. And it's probably the weakest part of her argument because just typically speaking, individualized standing arguments like this, they don't work. They just don't work. They haven't worked since Lyons. The Supreme Court, the courts in general have been very restrictive on this. And it's just too speculative to say like, well, hey, you know, I'm going to go back there. And maybe when I go back there, the government will go back there. And then, so I need some protection. It's just very speculative. And so I think, honestly, this is probably where it's going to fall apart. Anyway, here's how she concludes. The Fourth Amendment protects every individual's constitutional right to be free from arbitrary interference by law officers. After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work a certain type of legitimate job that pays very little, because this is unconscionably irreconcilable with our nation's constitutional guarantees. I dissent. So here's the thing about this case that I think's kind of silly. And I feel like this happens so often in Supreme Court decisions. Practically speaking, this almost doesn't matter at all, because this is such a specific injunction, and all it takes is just one additional thing. For instance, in Justice Sotomayor's opinion, she notes that the government in their brief pointed out that some of these locations where people were being seized had proven in the past to be almost entirely illegal immigrants who were there. And she says, well, that's not one of the factors that got banned, so we're not going to consider that. And she even goes further than that to say, and if that were the case, then obviously they would be able to conduct a search there, right? And it's like, yeah, the thing about this, just think about this for a second. Let's imagine that a Border Patrol vehicle pulls up to one of these locations where people who are here illegally tend to gather. What is immediately going to happen? People are going to start running. They're going to leave, right? That alone is enough for them to have individualized suspicion. They could then essentially detain every single one of those people who tried to leave and determine whether or not they're here legally. Now, if there was somebody who was just like cool as a cucumber and just you didn't do anything, then okay. But generally speaking, they're not going to have that problem. And that's why this case is a little strange, because you have this district court enjoining something that is so easy to get around, and yet it goes all the way to the Supreme Court, and you end up having this decision.
That's precisely why when I drive by a police car totally speeding, I just act like I did nothing wrong.
Exactly. Like, don't slam on your brakes.
But actually, it's precisely what you just said. I just let my foot off the gas and I look cool as a cucumber, looking straight ahead.
Exactly.
Well, that was a lot. I mean, yes, I can see that there are a lot of emotions and thoughts behind this, obviously, but it's helpful to note that this is not just in the immigration context. It has ramifications across basically how law enforcement officers are able to interrogate or detain in all of their duties, essentially. This being one of many duties that they do.
And the thing about reasonable suspicion, and it's an interesting thing to talk about, like the car stop thing is so interesting. Alice mentioned, like, you know, the police, let's say they stop you for speeding. They have probable cause to stop you for speeding because you were speeding. They have probable cause you were violating the law. That's why they can stop you, right? But what they can't do because you were speeding, they can't search your car, right? What they need to search your car is either your permission or reasonable suspicion that something illegal is going on. So how do they get reasonable suspicion? Think back to the last time you were stopped by the police. Did they ask you questions like, hey, where are you coming from? Where are you headed? Did they ask you questions like that? One of the reasons they do that is because if you say, oh, you know, I'm coming from the beach, I'm heading home. And they're like, well, that's interesting you say you're coming from the beach because the beach is that way and you were coming from the other direction, right? What they've just done is establish reasonable suspicion. You have answered a question in a way that is suspicious. And so now they have reasonable suspicion. Typically, it'll include other factors like you were nervous. Now, you might be nervous for any number of reasons. I don't know. You just got pulled over by the police, for instance. But for the purposes of reasonable suspicion, as long as it's not nervousness alone, if you're nervous and you answered the question about where you're going, you know, strangely, or you appear to be evasive, or you won't look at the police officer, or you're sweating profusely, like all these other little things add up to this reasonable suspicion. And once the police have it, then they can do things like detain you for further investigation. They can call and get the drug dog to come down, which they can't do based on a traffic stop alone. They have to have some sort of reasonable suspicion. So that's what you're seeing play out here. Now, the thing is, as I said before, every one of those things I just mentioned is specific to you. The extra step you're having to take here is if you have enough general factors, is that enough to stop somebody, right? And that's what the government's arguing here. Like, yes, these are all general, and alone you couldn't do it on any one of these bases. But if you put them all together, enough general factors together, that's enough to stop a particular person. That's the interesting substantive question that I think is going to be tackled. I think at some point, I don't know, all it would take for the government is to say, hey, fine, we won't do it based on those four factors alone. We'll have something else.
It's going to be something specific to them.
Yeah. That would take care of it. Now, they may want an opinion that says the generalized stuff is enough. And so that may be why they're doing this, and they may very well get it. But the other problem is probably this never makes it to a substantive decision because of the standing issue. It's so easy for the courts to kick this on standing that then you never get to this substantive question. But when this opinion came out a few weeks ago, I keep calling it opinion, it's an order, because there is no, as I said, majority opinion. Like, this was a really sort of controversial thing, and people really grabbed onto this as the Supreme Court is saying that, as Justice Sotomayor says, like, if you're Hispanic in this country, you can be stopped at any time. The papers, please type thing, right? Like Gestapo type thing. You have to constantly prove you're a citizen. It's not the job of the police to show they have some reason to believe you're not. You have to prove you are. And the police would say, the INS would say, that's not actually true. We do have an obligation to show we have a reason to believe it. It's just we think these generalized factors are enough. So we wouldn't, for instance, pull over somebody who was walking down the street in Los Angeles. That's not enough, right? But if you're in these certain locations working these certain jobs, then we're going to say we have enough.
So there you have, clear as mud, as usual. But when you hear the problem with kind of these more heated questions is that it's hard to just cut through to understand like what are the issues that each side are debating. And hopefully you've gotten that today, as opposed to just a generalized comment about this is either anti-immigrant or, pro-enforcement, whatever you want to call this. We're trying to get you to the substantive issues and why it matters, because like we've said all along, it has basis in precedent. This is not just something that's made out of whole cloth today. The statute existed before today. These opinions are from the 70s, but also it has ramifications in the rest of criminal law as well.
And I want to say, I think there's one really important thing that we always want to emphasize. There is this notion of just the courts are just out there. They take up these controversial issues and then they just make up everything from whole cloth. There is a statute on this, like a statute passed by Congress, signed by the president. The statute was originally passed in the 50s. It's been amended dozens of times in the 70 years since. No one has ever changed this. Like, you could, I'm going to say very easily, though that would require passing a law and having the president sign it. You could have a statute that says you can't do this, that says, in order for an agent to stop someone and check their immigration status, they have to have specific, particularized suspicion of that person, right? That's not what the statute's as broad as it could possibly be, to the point of being unconstitutional, frankly. Like, the statute as written violates the Constitution. So we have this thing called constitutional avoidance. And that's why reasonable suspicion is attached to the statute, because the courts are avoiding striking down the statute and saying what the Congress and president really meant was they can do this if they have reasonable suspicion. And DOJ and the various entities followed along with this and issued regulations under the statute that say the same thing, that what the statute means is they can stop you if they have reasonable suspicion. Now, reasonable suspicion, as we said, is the lowest bar you can really have in law enforcement. But I just think it's always worth pointing out that these are issues which, if in our representative democracy, you could get enough people to agree on, you could solve through some sort of legislation. I feel like we say this in so many of these cases, but this is another example where it would be nice just if people had as much energy in changing the law as they often do in trying to get a court to rule a certain way.
Well, that was pretty easy and light. And I still think the most controversial thing that I said tonight was my stance on the Taylor Swift album. So,
well, I'll top it. And just say I didn't like it. So now I have said the most controversial
is controversial is my point. You're darned if you do, you're darned if you don't. But we hope that you've learned something from this, and that if you have any questions, please ask us. If we haven't, explained something, please let us know. We hope these types of episodes are interesting and informative to you, because I do think this is incredibly important. This is, if you live in the United States, this is your Supreme Court. And these are decisions that affect you, even if you don't fall into this category of people who may be stopped, because this is the way we decide how we detain, interrogate people, and what, there's always going to be pros and cons to every sort of policing element.
And let me just say, like everything else the Supreme Court does, like, this is couched as an immigration issue. But if the definition of reasonable suspicion is expanded, that will apply in all criminal contexts, which means even if you're not an immigrant, don't look like an immigrant, speak English and no other language, if reasonable suspicion is expanded, then the ability of the police to stop you based on generalized suspicion will be greater. So you should care about it for that reason, if nothing else.
And on the opposite side, remember, there's always an opposite side. We hear this all the time when Maura Murray disappears. People say, why couldn't they just march into someone's house and search everything? On the other side, if you can't stop someone and it's more narrow or specific to the person and when you can stop, then you do have situations where maybe you call the police and you say, hey, this person's walking down the street and they're kind of walking stiff-legged as if they have a long gun in their pants and they have a trench coat on and it's 98 degrees outside. And they're like, you know what? Can't stop. I'm sorry. And you're yelling into the phone, but I just told you a bunch of factors that make it really suspicious and they're walking towards my house. What am I supposed to do? Sorry, the Supreme Court has spoken. So I'm just noting that there is the opposite side of the coin, and that's what we constantly have to balance in terms of what we're willing to give up with respect to our constitutional rights and where we shave kind of the borders of it. And it has real implications on both sides.
Amen.
Boom.
And that's the
Amen.
other thing. There's costs and benefits to everything. And that's another thing we always like to point out, because people do like to make it seem like all this is black and white, right? There is just 100% just, right, correct answer, and it has no cost whatsoever because it's obviously what we should do. And that's never true. Almost never true. I mean, there may be an example, but that is almost never true. Every single thing that we have comes with a cost. And that's just a fact. And the question is always, is it a cost worth paying?
And that's why this decision and these types of cases are worth discussing beyond just yelling about like big P politics. That's why this is important, and why it's important to be informed about it, so you can have reasonable and rational and informed debates about these very important questions that go beyond the context of just immigration. So with that, let's go on to something less controversial, maybe with a question.
So this one is very appropriate for this time. We're recording this in October, and I say it's appropriate not because it has anything to do with Halloween, but because it has to do with October's greatest sporting event, the baseball playoffs. So Alice, I'll let you answer this first because I know you're a huge baseball fan. This is from Texas Megs, and I think that's a she. And she wants to know, what is your favorite baseball team, and what is your favorite food at the games?
Well, I obviously love, it's not a pro team, but the biscuits.
The biscuits, baby.
Because
That's
they're
right.
the greatest. They're truly, I'm not even kidding about that. First of all, they're called the biscuits. So the first time I ever came to Alabama and got off the plane, there was like a big cartoon biscuit with a tongue that was a butter slab and googly eyes. And I was like, am I high? What is happening? Like, that was what greeted me when I got off the airplane in Alabama. And they were like, come see the biscuits. And I was like, is this a restaurant? What is this? And then I went to my first game and I was hooked because the camaraderie, they're good. They care. The fans care. Everybody watches. It's a fantastic. They're my favorite because, you know, hometown pride. My favorite food. Oh, that's a great one. I mean, I love stadium popcorn. It's so messy.
so
I
good.
love boiled peanuts. That might be a southern
I
thing,
do
though.
too. It's a southern
I don't know
thing,
if
but
boiled
yeah.
peanuts is like in Boston. Boiled peanuts are amazing, number one, but they're great at a baseball game because you can just throw, you have to eat boiled peanuts by just throwing the, you have to litter. You have to litter. You know, that's
course
just
you
the
do.
only
It's not
way to eat.
litter,
You can't
it's
like
compost.
hold all your nut, you know, casings because you'll never be able to eat everything. This just went X-rated. So it's so fun because you just get to let it all drop and then you eat it and you're yelling and they're like, it tastes great. So boiled peanuts are my favorite stadium food, which I think is just a southern thing.
So I also love the biscuits. I probably have more biscuits shirts than I do Alabama shirts. Like I'm usually, if I'm not
Whoa.
wearing,
Okay, that's actually kind of a big deal.
if I'm not wearing like a podcast shirt, which I am now, I have the consult on. Right now,
Nice.
I'm probably wearing a biscuit shirt. I got several biscuits hats.
This is true.
Love the biscuits. The biscuits are great. The biscuits, they used to have, and they got rid of this, you know, but they used to have biscuits at the stadium. In fact, they used to, when the biscuits would hit a home run, they had a cannon that would fire biscuits into the stand. And that was awesome. I feel like they cut all this because of, you know, cost and everything else. As far as food goes, I'm a big hot dog and beer guy. I love that. I will say this. I will expand upon my answer since Alice said the biscuits. So as far as professional baseball goes, I, like every single person who grew up in the South in my generation, have always been a Braves fan because
They were on
everyone,
TV, TBS.
Yeah.
Nonstop.
Everyone. I remember.
That was brilliant of them.
Oh, it was so
by
brilliant.
the way.
And there were no other teams, right? Like
There were,
There are several
yeah.
teams now. There were no teams in Florida, for instance. You didn't have the Marlins. You didn't have the Rays. You know, you just had the Braves. And I can remember going to football games, and they would announce Braves scores at the football games. It was like the only time everybody cheered because everybody there, like it would be an Alabama-Auburn game or Alabama-Tennessee or whatever. Everybody hates each other, but they announced the Braves score and everybody would cheer because everybody was a Braves fan.
Yes. I
We used to
forgot about
watch-
that as a kid. You're
We
right
used to
about
watch
that.
every single Braves game when I was growing up as a kid. Every single one. I'll say this, the strike really hurt that. I think that was kind of a break. It was like after the strike, it changed a little bit and people weren't as big into the Braves anymore. So I don't know what it's like now, but
I remember we had like a big screen TV. This is what my parents probably got it in the 80s, so it was early 90s. But it's like one of those big screen TVs where like the screen is, I don't know how to describe it. If you get too close, you can't see it because it's so like largely pixelated, and it's really thick. It's almost as like thick as it is wide, and so like you can't put your arms around it. That's how big the like big screen TV was. And we would have TBS Superstation on with the Braves all weekend, all the time. Really, that's what was on, because like we weren't allowed to watch like the racier shows like Saved by the Bell, And so we'd have like the Braves on. And then of course I have to mention the Astros because I lived in Houston and we went to like countless Astros games, and it's just they're a great team. The stadium's beautiful because they have it half covered when it's 99 degrees for most of the games. But I don't think I ever had boiled peanuts at the Astros game, so I don't know that they were there. I'm trying to think. I don't think they were there. I don't think so.
I still remember
like a Deep South thing.
Sid Bream sliding home in 92. I still remember that. Terry Pendleton, Glavine, Smoltz, Maddox, Avery, like Terry Gant, the crime dog, McGriff. I mean, like that, David Justice. I mean, those teams were just such a... So I still like the Braves. I was very happy when they won the World Series. But I don't really watch baseball anymore. I will say this. When I moved to Boston, I got up there. I hated the Red Sox. I always hated the Red Sox my entire life. But, like, being in Boston, it was just so overwhelming. I've never experienced anything like it. Like, how much those people love the Red Sox. It's just wild. Like, and this is coming from somebody who grew up in, like, college football craziness. Like... their whole lives were built around it. The day the trucks left from Boston to drive to spring training, just taking the gear down, they celebrated. That was truck day. They celebrated that. I mean, they just loved it so much. And so I remember they were playing the Yankees and they were down 0-3. And I had a friend who was a huge Red Sox fan. I said, look, man, for you, I will go get a Red Sox hat and turn this whole thing around. So I went down to Harvard Square. I got myself a Red Sox hat, which I still have. And they came back and won that series 4-3. So really, I am the reason for all the Red Sox success from 2004 onward. So I still will pay attention to the Red Sox as well.
That's a pretty good story, actually. Great question. That was a fantastic question. Thank you for Meg for asking that.
Do you want to say happy birthday to Lily? It's her birthday. Thank you, Lily, for joining us in the chat.
Happy birthday, Lily.
29. It's a tough year. Next one, you'll be over the hill, but it's okay.
29 for the 10th time. Well, guys, thank you for suggesting great topics for legal briefs. If you have any topics or any cases that you'd like us to cover, please email us at prosecutorspod@gmail.com. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Because you guys asked last night, I totally shirked all my other duties today and listened to the whole soundtrack.
Oh, there you
Showgirl,
go.
Life of a Showgirl. And I have a real now informed take. I don't know that anyone here, maybe nobody cares, so we can just move
No, we
on.
all care. I want to hear. What do you think?
Okay, hold on.
My
Drop
opinion, I
this
thought...
Waterloo on my like ankle bone. Doesn't feel great. Not really. Happy birthday, Lily. Sophie cares. Sophie cares and I care.
This October, fear is free on Pluto TV with horror movie collections from Paranormal Activity, The Ring,
You will die in 7 days.
Scream, and From Dusk Till Dawn.
This is my kind of place.
And don't miss the man-made nightmares in Mary Shelley's Frankenstein or the world-ending chaos in 28 Days Later.
There's something in the blood.
All the scares, all for free. Pluto TV. Stream now, pay never.
I earned my degree online at Arizona State University. I chose to get my degree at ASU because I knew that I'd get a quality education, they were recognized for excellence, and that I would be prepared for the workforce upon graduating. To be associated with ASU, both as a student and alum, it makes me extremely proud, and having experienced the program, I know now that I'm set up for success. Learn more at asuonline.asu.edu.